so much for having me, and Kate Kelly, who works in my office, she's with me. We have a series of meetings starting down here in Tacoma. So we're starting off with all of you. Then I do have to leave. I normally like to hang around after the Rotary wraps up and talk to folks one-on-one, but we are going right to the convention center. There's a gang summit going on to address issues of gangs in our state that's being put on with about 350 folks at the convention center. So I'm heading sort of directly right there afterwards. So apologies in advance for having to slip out after I'm done. But thanks for having us. We really appreciate it. This is, I'm in my 5th year as Attorney General. This is my 104th or 105th Rotary Club meeting, I think. So that's, I'm not sure if anyone's been to all 187 in the state, but that's my goal, is go to all 187. So
you realize we're in Canada, right?
So I'm working on it, and it sort of started by accident after I got elected to Rotary. Invited me to come speak, and so I'm not a Rotarian myself. I went and really enjoyed it. It was a chance to get out of the office, talk about what the office is doing, and to take questions and hear from people in the community about what they're focused on, what they care about in the office and the state. So one thing led to another, and next thing I knew, I had a goal getting to all 187 around the state. So we're working our way around it, but it's been great. Rotaries are in many respects in the same business that people in my office are in, which is every Rotary I go to, I discover they're very focused on taking students in their schools who they want to get scholarships for. They're helping people in their community in some way, in fundraising. They're doing stuff for their community, right? They're serving their community. Take my word for it, everybody who works in my office. We have an office in Tacoma, for example, in downtown Tacoma. We have 13 around the state. Everybody can make more money working for a private law firm. I guarantee you that. But they all choose to work for you because they're interested in service to the state and to the people of the state. Our office is a big one. We have about 600 attorneys, 600 professional staff, as I mentioned, 13 offices all around the state. So we're a large operation, the largest law firm in the state of Washington. And the one thing I mentioned always to my team is that in doing that work, the most important quality in doing that work is independence in the work that we do. We represent the state of Washington, so think of it as every state board, commission, agency, the legislature, the governor, we're their law firm. They decide what they want to do. It's like a business would decide, but they've got lawyers advising them. But the business person decides what they want to do. That's the same relationship we have with all of those state clients. We give them legal advice. Here are your options. They decide what they want to do. Another bucket of work we do is work we do directly on behalf of the people of the state of Washington. So think issues like civil rights, consumer protection, criminal justice, antitrust work. The client, so to speak, is all the people. I don't call up the governor to say, hey, I'm going to file this consumer protection action. What do you think of that? If I think it's the right thing to do, I do it. The client is all of you. That's our affirmative work we do directly on behalf of the people. So in doing all of that work, that independence is really important. We're lucky in Washington State. We've had a culture of independence in our office for many, many administrations. To give you an example, when I became Attorney General, there's 5 deputies who are the top lawyers in the office who advise the Attorney General. They oversee all the legal work. I asked the 5 deputies who served under Rob McKenna. He was my predecessor. Rob and I are different political parties. I asked those 5 deputies to serve for me. That's unusual, right? A new person comes in, you bring your own people, particularly if it's different political parties. I did not know those 5 deputies, but I knew them by reputation. They had an excellent reputation running a nonpartisan, independent law office. I didn't know them, but I asked them all to stay on. They all agreed. What I found out later on is Rob McKenna followed Chris Gregoire's AG. They're different political parties. Rob had asked all of Chris Gregoire's deputies to stay on and serve for him, which meant there's a fellow who retired earlier this year. His name's Rob Costello. He'd been a deputy over multiple administrations of different political parties. I'm willing to wager we're the only AG's office anywhere in the country where we can say that. Truly. Often a new AG comes in, they don't just hire the top folks, they fire line attorneys, just the basic line attorneys doing the day-to-day work on behalf of the state. Totally apolitical, those folks get let go. Both new Democratic AGs and new Republican AGs do that. That would be truly unthinkable in Washington State. I kept Rob's chief deputy, the top lawyer in the office. Again, I didn't know him, but I knew him by reputation. So that doesn't mean that everybody agrees with every decision I make or Rob McKenna or Chris Gregoire made as AG, of course not. But we come from a place of really valuing that independence. It's important who we are and as an office. So what I'm going to do is touch on a couple issues going on in the office, and then open up any questions you have. Cut me off whenever the right time is. And have again is, hey, anything you want to ask about going on around the state, I'll do my best to answer any questions you have. But I'll talk about 2 things that are going on. One is, when I mentioned that affirmative work we do directly on behalf of the people of the state, one of those areas is consumer protection. So we receive about 30,000 consumer complaints a year from the people of the state. That's people take the time to write or contact our office. It's a high volume. So in a nutshell, we enforce the state's Consumer Protection Act. It's a law that simply says you cannot engage in an unfair or deceptive business practice. That's literally what the law says. We enforce that. For your local connection to that law, it was John O'Connell, who was the Attorney General of the state from 1956 to 68, who was from Tacoma. I've been inside his home. He had a home here in Tacoma, not too far from where we are actually, a historical home. And he was the county prosecutor for a number of years before he became Attorney General. He was the person who actually came up with the idea of having a Consumer Protection Act and proposing to the legislature, and it was signed into law by Governor Rosalini in 1961, I think it was. But John O'Connell was the guy who made that happen. So we have a consumer protection team that enforces that. That's important for consumers who are harmed by someone not playing by the rules. It's also important for businesses that play by the rules. You should not be at a competitive disadvantage to a competitor who's not following the rules, right? Taking shortcuts, you should not be at a competitive disadvantage. So we enforce those laws. I'll give you one example. We had a case recently where there's an entity back in the Midwest. What they do all around the country is they send out, sort of their business model, is they send out letters focused on small to medium-sized businesses. So in Washington State, they mailed out, it was either 50 or 60,000 letters to businesses in Washington. And the letters looked like they were official letters, like from the state. They had a return address of Olympia. And the letters all said the same thing. They said, hey, business owner, you are late filing your corporate minutes with the Secretary of State. I often get nods. Maybe on some people I'm seeing nod, and invariably someone's nodding their heads that I got that letter. You're late filing your corporate minutes. It costs, I think it said $125, $100, something like that. $100, $125. Get it in, or bad things will happen. 2,900 Washington State businesses mailed in their $125. Why wouldn't you? I've looked at it. It looks legit. My late grandmother, Edith Hosman, my mom's mom, she, after the Depression, her husband died at a very young age. And so she was a single mom with 5 kids. And we had a meat market. That was the family business for many generations. So she took over the family meat market in 1935 or something like that, middle of the Depression, single mom, 5 kids, ran that business for decades. I'm guessing she was a pretty busy person running that meat market, right? If a bill came in the mail, you pay the dang thing and you move on, right? You don't have your in-house counsel to scrutinize it. 2,900 businesses mailed in their $125. As you can imagine where this is going, there is no such requirement to file corporate minutes. There is no such $125 fee to do it. It's all a scam. Now, we noticed other AGs would settle with this company for kind of pennies on the dollar, which made no sense to me, right? Those folks are out their money, they should get their money back, and there should be a penalty, a deterrent. So we took them to court, we won. So the judge did a few things. One, ordered that they give back those businesses their $125. So the business had to pay those folks back. We get all of our costs and fees back for bringing the case. There's no cost to taxpayers for us bringing it. Third, we asked for a penalty. And the penalty, I think, was basically $1 million. Either slightly over or slightly below $1 million. That penalty goes right to the state of Washington, general fund to use for whatever the legislature wants to use it for. Education fund, whatever they want. Consumer protection is one of the few money makers in state government, actually. And it returns millions and millions of dollars to Washington consumers every month, every year, and money back to the state. In fact, the Consumer Protection Division itself receives no general fund support. No tax dollars go to the 80 or so folks who work in consumer protection. It's all funded through those recoveries. The state gets millions, consumers get millions, and then some is held back to run the operation. Literally not a dime of general fund work dollars going to that work. Another one I'll mention briefly and then open up to your questions is an issue we've been spending a lot of time on, both on the policy side and the litigation side, related to opioids and the epidemic of opioid abuse in our state. It's going on all around the country, as you know. Washington is a hard-hit state, which is, people know, I think there's a problem. I'm not sure folks realize the scale of it here in Washington state necessarily. To give you just an example, the LA Times did a big story on the opioid epidemic around the country, and they focused on one community for their story. And it was Everett, Washington, Snohomish County. That's where they focused. On average in Washington State, 2 people die of an opioid overdose every single day. And to give you a sense of the scale of the amount of prescriptions of opioids that are going out in the state, and the volume is very, very high. I think in 2012 there were enough opioids prescribed in our state for every man, woman, and child to have the equivalent of a 16-day supply. Yeah. When we think about the scale of that, right, every man, woman, child. Pierce County, I got my stats for Pierce, has the 4th highest oxycodone prescription rate in the state, and the 12th highest opioid death rate in the state. It's a big issue. So we recently, a couple things happened. I get questions about this. I'll be very brief on this. Washington State filed a lawsuit. The AG's office filed a lawsuit against the largest manufacturer of opioids in our country. That's Purdue Pharma. They created Oxycontin, for example. That's their product. We believe they are deceptive in how they market it. We have a number of claims against them. A couple states have filed lawsuits against Purdue. We're now one of them. It's going to be big, complex litigation. Chris Greatwar, who was AG, took on the big tobacco companies. She's compared it to that type of litigation. It's a big one. To give you just one example of Purdue's conduct, there was a big 60 Minutes show on a couple weeks ago.
Yeah.
So if you haven't seen it, check it out. But they show a Purdue Pharma representative testifying before Congress 15 years ago, basically saying, "Oh, this stuff's not all that addictive." And that was their message. To such a point that when doctors started calling back to Purdue saying, "Wait a second, you told us this stuff was not going to be particularly addictive," we're seeing patients coming back and they're showing signs of addiction. They're showing characteristics of being addicted. What's up with that? What Purdue Pharma told those doctors is those folks are not addicted. That's something called pseudo-addiction. That's their word. That's pseudo-addiction. What they are is they're in pain. They're not addicted, they're in pain. And you only get one guess what Purdue Pharma told those doctors to do to treat that pain.
Give them more.
Get more pills. So, it's an important lawsuit, and we're bringing it on the policy side. We'll be proposing 2 bills before the legislature this year, or next year, I guess. As Attorney General, I can propose legislation, goes through the normal legislative process, but I can propose it very high level. 2 things very quickly. One is proposing pill limits. So right now, if you get your wisdom teeth pulled out, right, you'll typically get a 30-day supply of opioids for that. Do you need that?
No.
Does your 19-year-old kid need that, right? Do they need that, right? So a number of states now have moved to, like for example, a 7-day limit. Now, if you have chronic pain that's ongoing all the time, that's a certain category. But for a one-time event like that, you don't need a 30-day supply. One of 2 things is going to happen. You'll use all 30 pills because your doctor gave them to you, so you figure, I guess I'm supposed to, and you're going to have a problem, right? Or you use the 7 days worth, and the rest go on a shelf, and now those are on a shelf where the kids in your household have access to them, or a neighbor's kid, or someone in your family can access those. Neither of which are a good outcome. So we'll be proposing that. Before the state legislature this year. One more thing, very briefly, is we also have something called in Washington State. It's all set up. Something called the Prescription Monitoring Program, the PMP, the Prescription Monitoring Program. So if Kate comes in, I'm the doctor, she gets a prescription, that gets entered into the system. So we know Kate's got that prescription for those wisdom teeth. Doctors are not required, unlike other states, blue states, red states, who are trying to address this problem. In those states, a doctor, before the prescription goes to Kate, the doctor has to go on and check to see Kate's history of getting painkillers, opioids. And so doctors can see if Kate's pill shop, from doctor to doctor to get pills to feed an addiction. That's not pain she's in, she's got addiction. We do not have that requirement in Washington State. It's not too complicated. The system is in place, right? It's not like we have to build a system. The system's there. It's a matter of saying you got to check before you prescribe. We don't have that. That's something else that we'll be proposing again. Both those issues we mentioned, many states are now moving to those, and they're seeing success as a result, which is not surprising. These are common sense proposals that we think will make a difference and save lives as well. So I'm going to stop there. There's a lot going on in the office. Feel free to ask about any of those issues. There's issues like we represent the state on K through 12 funding. The Cleary case before the state Supreme Court. One of our lawyers was in court just the other day arguing that. We have litigation going with the Trump administration, which has been in the news a lot. Happy to talk about any of those cases. We have a lot going on with that. So feel free to ask about whatever you like. Yes.
What is the status of the immigration lawsuit?
On the travel ban?
Yes, travel ban.
So there have been 3 travel bans at this point, 3 versions of it. So the first one came out shortly after Donald Trump became president. Washington State was the first state to sue on that one. That applied, for example, to folks with green cards. 500,000 people in our country. There were students, faculty members at our universities who were impacted by that travel ban who could not return to Washington State, who were here living and working. We challenged that. We won the trial court, won the Ninth Circuit Court of Appeals. At that point, the Trump administration did not appeal to the U.S. Supreme Court, and they rescinded it. They paid our costs for having to reply to their appeal. So we won the first travel ban. 5 weeks went by, he issued a second travel ban. We challenged that, but Washington's case did not go in the courts because other state federal judges granted an injunction nationwide. So we actually, somewhat ironically, because we're involved in the first one, we're not involved in the second one. The second one went to the U.S. Supreme Court. Parts of it were allowed to continue, parts were not. It got complicated, went up and down, got complicated, but in a nutshell, for the second travel ban, part was allowed to go forward, part was not. Each of those travel bans, importantly, was limited in duration, either 90 days or 120 days, right? Now there's a third travel ban. The most important aspect of the third travel ban is that it's unlimited in duration. So it applies to a handful of countries, but there is no limit like the first two. It'll just go as long as the president wishes it to go or until a new president comes along. That's been challenged as well, again in Hawaii and in Maryland, I think. Injunctions have been placed on it. So again, our judge did not rule on again because injunctions got put in place. So the third travel ban has not gone into effect because it's been stopped by the courts. Undoubtedly, it'll end up before a U.S. Supreme Court, but we'll have to wait and see how that plays out.
So the state of Washington isn't a party with the third?
That's correct. We're seeking now, so our judge, Judge Robart, a judge appointed by George W. Bush, he was the one who ruled in our favor initially. He has not ruled in the second one or the third one because other federal judges already issued a nationwide injunction. Essentially he's saying is, well, hey, you've got the relief you want from a different judge. I don't need to issue a ruling on it, right? Which is not illogical, obviously, right? We are seeking to, I'll spare you the details, but in the Hawaii case, we're seeking to join that case of the Ninth Circuit. Unclear whether the Ninth Circuit will let us do that or not. It would not be unusual for them to say, sorry, we've already got our parties. But on the other hand, it's us and 4 or 5 other states that represent a lot of folks. They might let us join that litigation. But right now, no, we're not formally part of that current litigation. The one thing I'll just add about that is, there's a lot at stake in that litigation. Take the first travel ban, right, about who can travel and all that. And I get that these issues are controversial. A lot of people don't agree with my decision to sue. I guess one thing I'll just add is that in that case, the federal government, the Department of Justice, your Department of Justice, by the way, right, federal level, what they argued in court for the federal judges, the trial court and the Court of Appeals, was not just that the president has a lot of discretion to issue an executive order on immigration, which he does, right? He's got a lot of discretion. What they argued in their briefs was that the president's authority, I'm quoting from the brief now, is unreviewable by the courts. That's not how it works, folks. That's not how it works. In times of war, courts have reviewed presidential actions. It's never been the law. It's not the law now. I will not allow that to be the law. Presidents are not judges. We have a democracy. We have separate branches of government. We have a judiciary. It's how it works, right? Look, I'll be candid with you. That's arrogant to me to say that President Obama issued an executive order on immigration reform. A Republican AG in Texas challenged that. A federal judge in Texas said, nope, not constitutional, and that was upheld by the courts. He was limited by it. That's how our system works. And I realize that's inconvenient for presidents of both political parties, but that is the system. But they argued that in the trial court, they argued that in the Court of Appeals. I am proud that for the second and third travel ban, they walked that back. They got shut down because my legal team shut it down, right? But they walked that back. They no longer say, hey, courts, you can't even review what we're doing, which I think is an important principle as well. Yep.
What's the status of the lawsuit against the Northwest Detention Facility?
Yeah, thanks for mentioning that one. So the Northwest Detention Facility, which you folks are familiar with here in Tacoma, houses about upwards of 1,500 folks who are being detained. These are for immigration purposes, civil proceedings, not criminal proceedings. We filed a lawsuit against the owners of the detention facility. It's a private corporation, as you probably know, Geo Corporation, and it's a big corporation. They have a number of such facilities around the country, but it's a for-profit entity. So, long story short, at the facility, other than the security of the facility, right, where they hire folks, the bulk of the work done there, cleaning, for example, the kitchen, all that work, is done by folks at the facility itself, the detainees at the facility. In Washington State, we have a minimum wage. There are exceptions to paying the minimum wage. A county or state-run prison or jail, for example, is an exception under our state law for paying the minimum wage. There is not an exception for a for-profit company. Those folks need people to work there. They got to pay the minimum wage, whether it's detainees or hiring someone from the community who needs a job, needs a place to work, right? Right now, they're not. What they're paying them is $1 a day for the work. Sometimes it's not that. Sometimes they get paid in chips and candy. It's been going on for many years. So we filed a lawsuit saying, hey, if you want detainees to work, you pay them minimum wage. If you don't want detainees to work, hire someone from the outside. But either way, you got to pay minimum wage on it. So we think it's a strong case. Obviously, we'll see where it goes. But that's an important case. And that was just recently filed, so we're in the early stages of this.